Okay, well, welcome. My name is Jenny Snow. I'm the communications chair with the Alumni Club here in New York, and we are so pleased to welcome Professor Geoffrey Stone here this evening. He graduated from our law school and then proceeded to clerk for Justice Brennan, and then came back to us on the faculty and has been a member of the faculty ever since. He's a former dean of the law school as well as a former provost of the university. And we're fortunate because this semester he's actually a visiting professor at NYU, so it makes coordinating wonderful events like this much, much easier. So we're so pleased to welcome him here tonight. And yeah, I'll turn it over to Professor Stone.
Thank you, Ginny. I'm delighted to visit here for the fall so I could be easy for this event. It's always important to put the university first. I'm delighted to be speaking in honor of William Rainey Harper. Harper, as you know, was the founding president of the University of Chicago, one of the truly great figures, maybe the singular great figure in the history of American higher education. It was Harper's vision that really created the University of Chicago as an idiosyncratic and groundbreaking institution, which set the model for the great American research university, which dominates today throughout the world. And it was Harper's understanding of what was possible in higher education that really gave birth to this great component of American culture. I was thinking about what to say about Harper. I know lots of stories about Harper. And the one I wanted to tell is really relevant because I've been thinking lately about David Booth's $300 million gift to the university, which is a rather remarkable event. And Harper, as the founding president, had as one of his most fundamental responsibilities raising the resources that were necessary to enable a great university to spring up from nowhere in the marshlands of Hyde Park. And to do that in a way that would enable the recruitment of some of the very great scholars of his generation from places like Harvard, Yale, Princeton, Columbia. And to do that, he needed to be a very effective fundraiser. And of course, the single individual who was the one great philanthropist of the University of Chicago was John Rockefeller. And it was Harper who spent much of his time cultivating Rockefeller and getting him to give what actually in current dollars is the equivalent to $300 million to the University of Chicago. And Harper was insatiable in his demands on Rockefeller, and Rockefeller grew increasingly annoyed with Harper, saying, "Enough already. You know, I've given enough." And finally, he said to Harper, "Here's the deal. I am not going to be with you anymore unless you promise you will not again ask me for money." And Harper reluctantly agreed and made such a promise. And a few days later, they were together in church services. Rockefeller was a Baptist, and the university, of course, was founded as a Baptist university originally. And Harper and Rockefeller were sitting next to each other in the pew, and Harper says, "Dear God, please let Mr. Rockefeller give the university another $5 million. Which Rockefeller proceeded to do. We in Chicago, in Hyde Park, at the university, and particularly at the law school, have been very excited, as you might imagine, over the past couple of weeks and the past little over a week in particular. It's been a remarkable time in our nation's history, regardless of whether one is a Republican or a Democrat. What happened in the 2008 presidential election is truly extraordinary and historic, and it's something that should make all Americans proud. It's something that most of us probably never believed we would live to see. And the university and law school are delighted to have played a role in Barack Obama's career. Since I know from the questions and conversations before the event, a number of you are curious about Barack, I'll tell you two quick stories about my own relationship with him. I have the claim to fame, which now probably will lead my CV for the rest of my life, that I was the dean who first brought Barack to the law school, to the university. He was at the time a third-year student at Harvard, and he was the president of the Harvard Law Review. And one of my colleagues in the law school, Mike McConnell, also a graduate of the law school, who was very conservative, now a judge, federal judge, had published an article in the Harvard Law Review, and he said to me, you know, I had this guy who was an editor and edited my piece, and he was great. He did a terrific job, and he happens to be African American, and you know, we should be aware of him in terms of possible appointment to the faculty down the road. So I asked Doug Baird, who was then chair of the Faculty Appointments Committee, to look into this guy, Obama. And Doug called a couple of people at Harvard who said that he was terrific and he was absolutely somebody we should be interested in. And to our surprise, it turned out that Barack was coming back to Chicago because he was going to come back here and he was going to do some community organizing work and start his legal career in Chicago and was writing his autobiography. And so we had just created in the law school a program on law and government. And so I called up Barack and I basically said, we understand you're coming to Chicago, you're working on this book. We understand from some of your teachers at Harvard that you're interested in government service. We've just created this program. How about talking about the possibility of coming to the law school and being the first law and government fellow at the University of Chicago Law School? So Barack flew out and we talked about this, and he was very impressive, and he was, even then, I guess he was about 26, this was 1991, I think, he was very much who he is. He was polished and self-assured and poised and thoughtful, and when he left my office, my secretary, she's reminded me of this many times since, said to me, he's going to be governor of Illinois someday. Little did she know that she was undershooting. And the second story I'll tell about Barack, or really on myself, is some years later, after our first meeting, Barack was a state legislator and still teaching regularly in the law school. And he ran, of course, for Congress against Bobby Rush, the incumbent, and got his pants beat. And it was a pretty humiliating defeat for Barack. And a year or two later, he announced he was running for the Democratic nomination for U.S. Senate. And this would have been probably around 1990, I don't remember the year, 1996 maybe. No, I'm sorry, 2003. Sorry, I got the wrong decade, 2003 maybe. And Ab Mikvo, some of you know, and I were co-hosting a fundraiser for Bill Clinton, for the Clinton Foundation, the William Jefferson Clinton Foundation, some big hotel downtown. And there were about 1,000 people there, and there was Barack working the room. And I saw him, you know, in this large crowd, and he's, you know, going around shaking hands, putting his arm on people's shoulders and looking in their eyes very intently. And I thought to myself, what a waste. So about 20 minutes later, I find myself at the shrimp bowl, literally, with Barack. We were both getting shrimp. And I said, Barack, do you mind if I give you some advice? He said, no, of course not. I said, you know, I've been watching you here going around, you know, working the crowd. I said, why are you doing this? I said, you just got destroyed by Bobby Rush. There are like 7 candidates for the Democratic senatorial nomination, and they're all better known in Illinois than you are, which was true. And the incumbent, Richard Fitzgerald, who was a very popular Republican senator, I said, he's not going anywhere. So you're just wasting your time. Why don't you just pack it in and come be a full-time law professor and make something of yourself? And he looked at me and he said, I really appreciate that, Jeff. He said, but you know, I really feel I have a responsibility, and I really feel I have an opportunity, and I have to do this. And I remember he turned and walked back into the crowd, and I thought to myself, what a putz. So don't trust me for career advice. Okay, so what I want to talk about this evening is the Supreme Court after the election. And when I offered to give a talk on this subject, I, of course, didn't know what was going to happen on November 4th, so it was a little bit up in the air as to what kind of a prediction, what kind of a projection into the future I was going to make. So many people, including myself, have very high expectations of Obama. And what I want to talk about tonight is whether he will make a difference in the U.S. Supreme Court and what that means in terms of the current Supreme Court and how we should think about the court in terms of Obama's presidency. One thing is clear, and that's that John McCain and Barack Obama made evident in the campaign that they had very different visions about the kind of justices they would nominate to serve on the Supreme Court. McCain said repeatedly that his idea of the ideal justice was exemplified by people like Roberts, Alito, Scalia, and Thomas, and he would want to see more justices like that on the Supreme Court. And Obama made clear that he had a very different view, that his perspective was that justices like Ginsburg and Breyer were much more the type of individuals who he would like to see on the Supreme Court. So I want to make several observations about the current state of the court, the background against which Obama will make whatever nominations he gets to make. First point I want to make, which will be fairly obvious to those of you who are lawyers, but maybe not quite so obvious to those of you who are not, is that you should not be deceived by the conventional wisdom of the media that this is a balanced court. Because there are so many 5-4 decisions, the media often treats the court as if the fact of 5-4 division is evidence of balance. And nothing could be farther from the truth. The fact is that this is an exceedingly conservative court. I want to come back to that point in a moment. But first I want to burst this idea that the court is balanced. And the reason why the fact that there are so many 5-4 decisions should not deceive you into thinking that it's a balanced court in any way that means anything is that the Supreme Court is a court that has discretionary jurisdiction. That is, it decides which cases to decide in any given term. And it actually agrees to decide something like 2% of the cases that are eligible for review in the Supreme Court. And the process by which the justices decide which cases to hear is a fairly complex one. But fundamentally, what the justices do is they pick the hard cases. And the hard cases are ultimately those cases which are likely to divide the court 5-4. And so any group of Supreme Court justices, whether it was 5 Scalias or 5 Earl Warrens, would very quickly result in selecting those cases that would divide that particular group of justices 5-4. And what really matters is not that the court divides 5-4, but where on the spectrum that division point actually occurs. And in the context of the current court, it occurs very far on the conservative side of the spectrum. And again, that may be good, bad, or indifferent, depending on one's view of the appropriate role of the Supreme Court, but it is important to understand that this is not a court that's balanced if measured against any ordinary understanding of the spectrum of views within the legal profession, for example. So the proposition that it's a very conservative court is, of course, somewhat in the eye of the beholder, but not entirely in the eye of the beholder. So there are several objective or reasonably objective factors that one could identify to substantiate this claim. 7 of the 9 current justices were appointed by Republican presidents. Now, that's in part due to the fact that Republicans have tended to control the White House over the past 30 or 35 years. It's also due to the fact of accident of timing. That is, there are more justices appointed by Republican presidents proportionately than Republicans have controlled the White House in that period of time. But the fact is, it's in part the product of the fact that most of the nominations have been made by Republican presidents. But that doesn't take away at all from the fact that it's in fact a very conservative court, 7 of the 9 justices having been appointed by Republicans. More than that, 12 of the last 14 justices have been nominated by Republican presidents. So this trend is not only a current trend, but it goes back for quite a substantial period of time. Another fact that I think is reasonably well accepted by constitutional lawyers or scholars without much disagreement is that 4 of the current justices are more conservative than any justice who has sat on the Supreme Court in the living memory of anyone in this room. Alito, Roberts, Scalia, and Thomas are, by any reasonable measure of the justices of the Supreme Court in the past 75 years, the 4 most conservative justices who have served on the court. Another fact that's relevant to this is there's no current justice who would reasonably be understood as a liberal justice. That is, if liberal means justices with the perspective on the role of the Supreme Court and on constitutional law, illustrated by Warren, Douglas, Brennan, or Marshall, there is no justice on the current Supreme Court who comes close to fitting that description. All of the current justices who are regarded as liberal are basically moderate to moderate liberal on a broader spectrum of the legal ideology. And indeed, the current justices who are on the left or perceived on the left would be the first to admit that. Justice Stevens, for example, has said repeatedly that he regards himself as a centrist justice, and the only reason he is regarded as a liberal justice, and he is now regarded as probably the most liberal justice, he says, is because the background has changed. And the other justices against whom I measured have become exceedingly conservative, so I kind of look like I'm a liberal. And although I think Stevens is guilty of a little bit of self-deception there about his own evolution over time, he's basically right. I mean, basically, Stevens is a justice who 40 years ago would have been regarded as quite centrist on the Supreme Court. Another way of understanding this is that for those who know something about the workings of the Supreme Court, because the court always tends to divide 5-4, no matter who the justices are, you can measure where the court sits on the ideological spectrum by looking at who's the swing justice. And over the course of the last 30 years, the swing justice has moved from Potter Stewart to Lewis Powell to Sandra Day O'Connor to Anthony Kennedy. And again, for anyone familiar with the performance of those justices, that's a straight march to the right. Each time the swing justice has moved, it has moved within the existing court demonstrably to the right. And one final example of this, which is actually a point that Justice Stevens made about a year or two ago, which was really quite illuminating and correct, is every single justice appointed to the Supreme Court over the last 30 years, with the sole possible exception of Ruth Ginsburg replacing Harry Blackmun, has moved the court to the right. That is, every single appointment is more conservative than the justice that he or she replaced over the past 30 years, since Justice Stevens' appointment. So what we have today is a very conservative Supreme Court, a court that's really more conservative than any makeup of the court in at least the past 75 years. Okay, now, I've been throwing around the terms conservative and liberal, but of course they're not self-defining, and so what I need to do is say a little bit about what I mean by the terms liberal and conservative to give some content to those definitions. So by liberal justice, I will take as an example justices like Warren, Douglas, Marshall, and Brennan, who were kind of regarded as the heart and soul of the Warren Court and the paradigm in the modern era of what one means by a liberal justice. So what were they? What did they do that earned them the reputation, for good or for ill, of being liberal justices? Well, they were very aggressive in the use of judicial power to hold unconstitutional acts of the democratically elected branches of government at both the state and the federal levels in a certain set of cases. That is, the liberal justices had a very defined understanding of when it was appropriate for the Supreme Court to be activist in its power to hold laws unconstitutional. They believed and they acted in a way that limited the authority of the democratically elected branches of government in those situations when they felt the democratically elected branches of government were systematically disadvantaging those groups in society that were traditionally the oppressed, the dissenters, the minorities, the disenfranchised. They had a clear sense that the constitutional responsibility of the Supreme Court was to play a role of limiting one of the dangers of majoritarianism, which is that majorities are not always wise, they're not always tolerant, they're not always respectful of difference, and they're often likely to act out of motives of intolerance and impatience and panic and hysteria and frustration to the disadvantage of those groups that are traditionally and historically disadvantaged in society and don't have the capacity always to protect themselves so well in the majoritarian democratic process. So one clear element of the Warren Court, the sort of paradigm of the liberal court, was that it acted in defense of those groups against what the justices thought to be an abuse of majoritarian authority. And the second area in which liberal justices have used the power to be activist was to put a check on overreaching by political majorities. That is another danger of democratic majoritarianism. One of them is a lack of respect for difference and a lack of tolerance for disagreement. The other is the danger of capture. That is that at any given point in time, a political majority will be tempted to use its authority as the political majority to change the rules of the game so that they will continue to be the political majority. And therefore, another important feature of liberal activism was restraining the ability and the temptation of democratic majorities, democratically elected majorities, to jigger the rules so as to ensure that they would perpetuate their own power. And so the Warren Court liberal justices were particularly careful to scrutinize various types of legislation that had the clear intent and effect of perpetuating the power of those who were at any given point in time in authority. So if you look at the jurisprudence of the Warren Court, and I sort of use them again as the modern example of what was regarded as judicial liberal activism, almost all of the most important decisions of those justices can be easily understood through these two concerns. That is, decisions like Brown versus the Board of Education involving racial segregation, decisions about the use of the poll tax or literacy tests, both to disenfranchise minorities and to enfranchise those in power, decisions involving the school prayer, disrespecting the interest of religious minorities, decisions of the court involving the First Amendment, free speech and free press clauses, which were designed to protect the rights of communists and other dissenters from majoritarian intolerance, decisions involving libel laws and the freedom of individuals to criticize public officials, one person, one vote, ensuring that the political majorities didn't entrench themselves in ways that were in fact, democratic. Almost all of the decisions involving the rights of those accused of crime, cases like Miranda versus Arizona, almost all of the decisions of liberal activists can be understood from this era as designed to further these two fundamental ends of protecting against majoritarian intolerance and protecting against capture. Okay, so justices who take that view are, I think, fairly described, for better or worse, as liberal justices, as exemplified by Warren, Douglas, Brennan, and Marshall. So that's what I mean by liberals. And there's no justice on the current Supreme Court that takes this mission as seriously as the justices of the 1960s and early 70s did. Okay, now conservative is more complicated. It turns out there are, by my simple analysis, at least three very different types of judicial conservatives. And it's very important to distinguish among them because we've tended to be very much misled over the past 35 years by phrases like strict constructionist, which actually have no meaning in substance, but which have become a kind of jargon that have become the rhetoric by which conservatives have tended to suggest we follow the Constitution, they make up the law. So what I want to do is to unpack a little bit what is meant by this phrase strict construction, or we follow the law and they make up the law, because it turns out to be a highly misleading conception. And there are at least three different varieties of judicial conservatives, and it is really important to understand the differences. So the first type of judicial conservative is what we might think of as the judicial pacifist. That is, the judicial pacifist believes in judicial restraint as a matter of principle. And the judicial pacifist believes that this is a democratic society in which the rule of the majority should dominate, and that courts should only intervene to invalidate the actions of the democratically elected branches of government when a law is beyond a reasonable doubt unconstitutional. All benefit of the doubt should go to allowing the majority to do what it wants. And that only in extraordinary circumstances should a court intervene to prevent democratically elected majorities from having their way. Now, judicial passivism, judicial restraint, was the version of conservatism that was articulated at the time that Richard Nixon was elected in 1968. Being a critic of the Warren Court, what Nixon talked about when he said we need to have a new type of justice on the Supreme Court was what he was talking about was judicial pacifists. They would no longer be the activists of the Warren Court era, who Nixon believed were unduly intruding upon the ability of the majority on issues like school prayer and racial segregation and rights of criminal defendants. And he said what courts need to do is withdraw from this. And so we wanted people who were principled judicial activists, sort of like Frankfurter was of the prior generation. And when he nominated justices like Powell, Berger, Blackmun, and Rehnquist, what he was trumpeting was a particular philosophy that basically said judges should withdraw from activism. And they should do this as a matter of principle across the boards. And indeed, all four of the justices that Nixon appointed at the time were exemplars of what I think Nixon was talking about. Now, a couple of things to observe about this. First is that is a principled approach to constitutional interpretation. That is, it's ideologically neutral. It basically assumes that we give the benefit of the doubt, we give deference to what the majority wants, and we only intrude on that majoritarian impulse in very rare circumstances, much less aggressively than the Warren Court did. Second point to make about this perspective is that, in my view, although it's principled, and although it's not necessarily politically conservative or liberal, that just depends on what the majority choose to do, in terms of whether passivism is liberal or conservative. It just depends whether the democracy at any particular point in time is being liberal or conservative politically. So it's not ideologically necessarily balanced or tilted in one direction or another. But the real problem with judicial passivism is that it abdicates a fundamental responsibility that I believe courts were intended to have in our constitutional framework. That is, the framers of the Constitution were very worried about majoritarianism. They feared majorities that run amok. And one of the reasons they created judicial review, one of the reasons they created judges with life tenure, and one of the things they clearly looked to courts to do is to be a check on irresponsible majoritarianism. And so the problem with judicial passivism, in my view, is that it has the virtue of being principled, it has the virtue of being ideologically neutral in theory, but what it does is to abdicate a fundamental responsibility that courts were intended to have in our constitutional system. We were not intended to be a run-amok democracy. It was intended to be a government that was very uneasy about democracy. The whole notion of separation of powers and of checks and balances was designed to make it difficult for momentary majorities to have their way. And one critical part of that was the role of courts to, in fact, put a check on democracies when they did act in ways that were intolerant and hysterical and panicked and so on. Now, the other important point about judicial passivism is there's no justice on the current Supreme Court who is remotely a judicial pacifist. So although it describes a view of constitutional law, in fact, it describes no justice on the current Supreme Court. No current justice behaves as a judicial pacifist. And despite the rhetoric about strict construction and the like, in fact, no one on the current Supreme Court fits that description. It's a null set insofar as the current Supreme Court is concerned. Okay, the second type of judicial conservative is what we've come to call an originalist. And these are justices who take the view that the Constitution does have bite, it does have meaning, and it is appropriate for the court in the right circumstances to tell the majority that it may not do certain things even though they're acting in a democratically elected way. But They also are worried about muscular judicial activism because they fear that judges will be tempted to make up as they go along what it is they don't like, and that they'll therefore be inclined to be very ideological in their interpretation of a very vague constitution, and that what judges will then do is to slip over into being ideological based on their own policy preferences, dressing it up as the meaning of the Constitution, and be anti-democratic and anti-majoritarian, not because they're actually fulfilling some function that's built into the Constitution, but because they are simply writing the Constitution as they feel like it and pretending what they're doing is interpreting some document. And so what the originalists say is, okay, there is a legitimate role for courts to play, but we have to be very careful about the danger that judges will make it up as they go along and substitute their policy preferences for law. And so the originalists say there is a solution to this problem. And the solution to this problem is that judges should enforce the Constitution aggressively, but only insofar as the framers of the Constitution intended it to be enforced aggressively. So what we have to do is to ask, what is it that those who drafted the particular specific provisions of the Constitution expected to be unconstitutional and intended to be unconstitutional, and that we should enforce rigorously. But beyond that, we should regard it as not within the purview of judges to interpret otherwise vague provisions. Now, in theory, this is a perfectly sensible and principled approach to constitutional interpretation, and it's an approach that, I should say, does not necessarily lead to politically liberal or conservative results. Originalism sometimes might lead to invalidating conservative laws. Sometimes it might lead to invalidating liberal laws. It's not necessarily a political or conservative ideology, but it has deep flaws. And the deep flaws are at least twofold. First flaw is that it assumes that justices are actually adept at discerning the original expectations and intentions of the framers who may have lived 220 years ago. The problem is that it's not so easy to do that. The framers did not, in almost any interesting area, debate, discuss, and decide what they intended in any concrete way these vague, open-ended provisions of the Constitution were intended to mean, or even what they expected them to mean. So the reality is that if one looks back into the history and tries objectively, neutrally, and fairly to discern what the framers intended with respect to a whole range of controversial problems, most of the time you can't actually get any historically sound answer. They didn't talk about these questions when they were drafting these provisions. They simply didn't have much of a conception as to what these provisions meant in any specific way. So what happens when the justices who purport to be doing originalism undertake an originalist inquiry is actually fairly predictable. What happens is they say to themselves, well, let's see, the framers must have been reasonable people. So they would have intended that these provisions would mean what a reasonable person would mean. I'm a reasonable person. I know what I would have intended. So this must be what they intended. And so what most of the justices who invoke originalism tend to do, not surprisingly, is to go through the historical exercise and come up with the conclusion that the framers intended just what they would have intended had they been framers. And so it turns out that those who advocate originalism, and really only two justices on the current Supreme Court ever invoke originalism as a serious enterprise, Scalia and Thomas, and they do it only very sporadically. But when they do it, it almost always, not 100% of the time, in fairness, but almost always comports with their own inclinations and biases as citizens. And so when it comes to interpreting the 14th Amendment, for example, Scalia and Thomas, who strongly oppose affirmative action, find that the original intention of the framers of the 14th Amendment was to prohibit affirmative action. Well, that's ludicrous. The framers of the 14th Amendment never thought about affirmative action. It was the furthest thing from their mind at that time. or they find that the framers of the Second Amendment intended to prohibit regulations of guns. Well, again, as Dick Posner has written recently, the opinion of the Supreme Court a year ago invalidating the D.C. gun ordinance written by Scalia on the guise that this was an originalist understanding of the Second Amendment is completely manipulative of the history. And that other people looking at the history with different views would quite reasonably come out with different perspectives. So one thing wrong with originalism is that in theory it's not a bad idea. In practice it's essentially impossible, and it opens itself up to smuggling one's ideological views into the enterprise of purporting to find the original intent of the framers. It's a cynical effort to justify not strict construction, not applying the law in some neutral way, but simply imposing one's viewpoints into the Constitution under the guise of attributing those views to the intentions of the framers. The second problem with originalism is that it's fundamentally incompatible with what the framers originally intended. That is, the framers of provisions that say Congress shall make no law abridging the freedom of speech or of the press, or that no state shall deny any person life, liberty, or property without due process of law, or that the government shall not deprive any person, inflict upon any person cruel and unusual punishment, did not intend those sorts of provisions to be narrow, crabbed, statutory-like codes based upon what they at the moment happened to think those provisions might mean. They'd never lived in a world with a guarantee of free speech, or a prohibition of cruel and unusual punishment, or of unreasonable searches and seizures, or of due process. They didn't know what those things meant. They thought they were aspirations. They were values that needed to be understood and interpreted and lived, and were not clear. And the last thing in the world they thought they were doing in embracing these open-ended provisions was enacting very specific, concrete, limiting definitions based upon the world they lived in. They were much too smart for that. They knew they were not adopting something that was specific and concrete. They knew they were adopting something that was open-ended and vague and subject to interpretation and complicated and difficult. And so they didn't believe in originalism. It was the last thing in the world that the framers believed in, was that they would trap the future in their conceptions of their world. So the second difficulty with originalism is that it's intellectually dishonest, not only in the sense that it's applied in a dishonest way, but it's actually non-originalist. Okay, the third form of judicial conservatism is by far the dominant form on the current Supreme Court. It clearly captures the views of Roberts, Alito, and Kennedy, and it clearly captures the views of Scalia and Thomas in all cases where they're not being originalist. And here it's really important to understand that that judicial conservatism on the current Supreme Court is not passivism. The current Supreme Court is more activist than the Warren Court was. It invalidates more laws as a percentage of its decisions per term than the Warren Court did. But what it does is invalidate a whole different set of laws. And so if you want to know what judicial conservatism is, or what conservative activism is, which is the dominant methodology on the current Supreme Court, the only way to figure it out is the same way you could figure out what judicial liberalism was. That is, look at the results that the justices reach and then work backwards from that. Don't tell me what you think. Let me look at what you do, and let me then draw inferences from what you do to what you think. So with the Warren Court, you can infer what they were doing, not only by what they said, but by looking at the results, looking at where they used judicial activism aggressively, and then you could say, what explains this pattern of decisions? And in fact, there's a very clear explanation, which is what I gave earlier, as to what motivated them to choose to use judicial review aggressively. So with the current conservative majority, it turns out that there is a much more idiosyncratic set of results that, in my view, cannot be explained from any coherent judicial, constitutional, theoretical perspective. So where do these justices use judicial activism? What do they invalidate? Okay? They invalidate laws regulating commercial advertising. They invalidate laws regulating corporate campaign expenditures. They invalidate laws regulating the use of guns. They invalidate laws allowing affirmative action. They invalidate laws regulating economic matters. They invalidate federal laws that regulate guns in schools or that regulate the environment. Basically, there is no principled, coherent theoretical framework that can explain this pattern of decisions. The only thing that can actually explain this pattern of decisions is the imposition of a particular set of ideological views about the good society, about what they think government should do and should not do. So let me give two dramatic examples of this quickly, because I think it's important to understand the concrete aggressiveness with which conservative activism exists within the current Supreme Court. First, let me give the example of Justice Rehnquist and the First Amendment. Rehnquist served on the Supreme Court for over 30 years. He decided some 260 cases involving freedom of speech or freedom of press that were non-unanimous decisions. So I'm putting aside unanimous decisions because they're kind of uninteresting because everybody agrees on the case. 260 non-unanimous decisions involving freedom of speech or freedom of the press. Rehnquist voted to invalidate the law 8% of the time. 92% of the time he voted to uphold the law. His colleagues, including conservative as well as liberal justices as a whole, voted 55% of the time to invalidate laws that involved freedom of speech or freedom of the press. So Rehnquist was only 1/7 as likely to hold unconstitutional laws challenged on the ground that they violated free speech or free press. Okay, that may be judicial pacifism. Nothing necessarily wrong with that. So then you ask, well, what are the 8% of the cases where Rehnquist voted to invalidate laws on the ground that they violated freedom of speech or press? Well, not a one of them involved the rights of a dissenter. Not a one of them involved freedom of the press. Every single one of the 8% of those cases involved one of several categories. They were the rights of commercial advertisers. They were the rights of corporate and wealthy individuals to spend unlimited amounts of money in the political process. There were rights of religious organizations to have freedom of expression. And there were the right of the Boy Scouts to exclude gays and lesbians on the ground that to require them to admit gays and lesbians violated the First Amendment rights of the Boy Scouts. That's the entirety of the 30 years of Rehnquist jurisprudence on free speech. There is no principled understanding of the First Amendment that gets you there. Now, Rehnquist didn't know he was doing this. He was voting in each of these cases. But if you step back and look at the pattern of the voting, it's quite clear that he simply had no regard for freedom of speech or the press, except when commercial advertisers, corporate and wealthy individuals, religious expression, and the Boy Scouts were involved. That's it. Okay, the other example I want to give is Bush versus Gore. And from a particular perspective. In Bush versus Gore, Justices Scalia and Thomas voted to hold the Florida Supreme Court decision that would have required a recount unconstitutional under the Equal Protection Clause of the 14th Amendment. Now, I happen to think this was a reasonable understanding of the Equal Protection Clause. However, the question is, what was going on with Scalia and Thomas in terms of their understanding of the Equal Protection Clause? So if you look at Scalia and Thomas's votes in all equal protection cases up to Bush versus Gore, it turns out that, first of all, put aside affirmative action. There were 19 votes they cast between them in cases involving affirmative action. Every one of the 19 votes were to hold affirmative action programs unconstitutional. So they were completely consistent. Everything designed to promote diversity violated the Equal Protection Clause. They cast 46 other votes besides those 19 involving the Equal Protection Clause. In only 2 of the 46 did Scalia or Thomas ever vote to hold any other law to violate the Equal Protection Clause. These were laws that discriminated against blacks. They were laws that discriminated against women. They were laws that discriminated against gays. They were laws that discriminated against Hispanics. They were laws that discriminated against dissenters. In only 2 of the 46 cases did they vote to hold those laws unconstitutional. But in Bush versus Gore, they invoked the Equal Protection Clause to invalidate the recount that would have had a recount in favor of Al Gore. So what does the Equal Protection Clause mean to Justices Scalia and Thomas? Again, if you forget what they say, if you look at their votes, it basically means that the government may not attempt to address issues of lack of diversity, that violates the Equal Protection Clause, and George Bush wins. Now, I don't like to be so cynical, but you also can't blink reality. So this is the dominant conception of conservative jurisprudence in the Supreme Court of the United States today. It is not principled, it is not theoretical, it is not neutral, it is not consistent. It is the exercise of political will to use the judicial power to affect a political agenda. Now, do these justices know they're doing this? No, not really. They don't think this way. They're not thinking about being political or partisan. But this is what's actually motivating them when you look at the pattern of their decisions. Okay, final point, and then we'll have time for questions. So is Barack Obama going to make a difference? The answer is no. He will make a difference relative to John McCain. Had John McCain been elected president, the Supreme Court would have moved even much more dramatically to the right from where it is today. Most likely, the conventional wisdom is that the justices who will retire over the course of the next 4 to 8 years happen to be Stevens, Souter, and Ginsburg for a variety of reasons. They are, of course, 3 of the more moderate to liberal justices on the Supreme Court. If John McCain had been elected president, he presumably would have replaced 1 or 2 or all 3 of those justices when they retired with people like Roberts, Alito, Scalia, and Thomas, which is what he regards as the model justice. What that would have meant is Justice Kennedy would have become a liberal, and the swing vote would have moved from Kennedy to John Roberts, or Samuel Alito, or Antonin Scalia. Well, that may sound crazy, but if I told you 20 years ago that Tony Kennedy would be the swing vote, you would have laughed. It would have been ridiculous. A Reagan appointee being in the middle of the court. Are you kidding? But that's what would have happened. And that would have been an era of a very much more conservatively activist, aggressively conservatively activist Supreme Court than even the one we have today. With Obama as president, in all likelihood, none of the 5 conservative justices will retire, unless one of them gets very ill. For reasons of age and political self-preservation, it's unlikely that any of those 5, Roberts, Alito, Scalia, Thomas, or Kennedy, will step down in the next 4 or even 8 years. So what that means, all that Obama can do over his 2 terms, if he has 2 terms, in all probability, is to simply leave the court with Justice Kennedy as the swing vote. And he can appoint people who are maybe to the left of some of the current justices, maybe in the same place as them, but it won't make any difference in terms of the basic balance within the Supreme Court. So the most one can say about this outcome with respect to Obama is, for those of us who believe the current Supreme Court is wildly out of whack with responsible, normal, legal, constitutional thought in this country, Obama can't improve that situation. However, he can, by his election, prevent it from becoming much worse. Thank you very much. Thank you.